Greetings, Attorney Derek DeBrosse here. Munitions Group, munitionsgroup.com. Look us up there. Go ahead and hit the like button. Follow us on YouTube. We also have a podcast with Attorney Steve Palmer. You can check us out there as well. Today we're coming to you. Today is December 8th, and we're coming to you to give you an update on the arm brace rule. Now, it's a little bit, I wouldn't say dated. This ruling actually came out, I think, on November 8th. It was actually filed in the Northern District of Texas, Amarillo Division. So we're going to give you an update, what's going on with that, just a little bit about what's going on at the office. You might have seen some new faces. My law partner, Clay Cheshire, another attorney in our office, Michael Truman's got some materials that's coming out, and my other law partner, Adam Barney, talking about a variety of things. So please continue to drop comments so that we can use that to get topics to discuss. But let's get to it. So just to give you guys a little bit of a backdrop. So about a month ago, I went ahead and did a video on an update to the arm brace rule. This is the rule that dealt with whether or not a arm-braced rifle, generally a AR-15 style firearm, is considered a National Firearms Act regulated firearm and it needs to be registered. If you remember correctly, a rule came out through executive order. It gave an amnesty date, I believe, of May 31st. If you don't register your arm-braced rifle by then, it would be essentially a crime, or you would have to register it and actually pay a tax. The amnesty period was to avoid that tax. There were some cases that came out. The primary case was Mock, M-O-C-K versus Garland, and I talked extensively about that about a month ago on this show. And in that case, there was a stay put on the enforcement of that rule, but it didn't apply to everybody who had one of these in the entire country. It applied to certain classes of individuals, individuals of certain nonprofit organizations, and I think owners of certain branded firearms. I can't remember. Maximum Defense, I think, is what it was. If you own a Maximum Defense, you wouldn't be enforced against you. Nevertheless, in that case, the reason they did put a stay on it, they basically, essentially, the court came down and said, procedurally, the rule wasn't done correctly. When the rule was first promulgated, it had this worksheet 4999, that had all these elements, 1, 2, 3, 4, 5, 6, and it was like a point system. If you're going to have this, you get this many points, so on and so forth. And if you have this many points, it's considered an FA item. You know, not a great rule, of course. None of this is. But at the end of the day, at least there was some finality to it, I guess, and easy way to determine it. But when the rule actually was published and came out officially for comment, if I remember, or before it was actually validated as a rule, it came out that worksheet was done away with. Long and short of it is the rule didn't end how it started, and so there's a theory in the law called the logical outgrowth test. And because the changes were not a logical outgrowth of the original rule, they said it's illegal. It's got to be set aside. And so they stayed as pertaining to those individuals. So now we fast forward to November 8th, and I'm reading from the notes. I'm going to walk you guys through just generally this opinion of this district court. Happened in the United States District Court, Northern District of Texas from Amarillo Division. Case number 223 CV19Z, and this is the Brito case, BRITTO versus ATF. In this case, we have 3 Marines that are decorated Marines, and I think one or all of them actually were harmed in combat, served in the same theater I did back in Operation Enduring Freedom and Iraqi Freedom. And they use these arm-braced pistols for safety, stability, recreation, for a variety of reasons. So they brought this lawsuit. So the end result, let me start with that, of this case was there's a nationwide preliminary injunction now, basically meaning that this law cannot be enforced until this case goes to trial and it's actually heard on its merits. So with that said, how did the court actually reason its way to this decision when the Fifth Circuit didn't reason its way to the same decision? So first off, a preliminary injunction, there's a standard. There's 4 elements that a plaintiff must prove, and they have to prove there's a substantial likelihood of success. They have to produce a substantial threat of irreparable harm. If the injunction's not issued, that if this is enforced against them, there'll be irreparable harm. 3, the threatened injury must outweigh any harm that will result if the injunction is granted. Harm to the public or to the government. And then 4th, the granting the injunction is actually in the public interest. 3 and 4 are always kind of joined. Does the public or the government's interest essentially outweigh the interest of the plaintiffs? That's another way to kind of think about that. So as the court went forward, there's a couple quotes I'm going to read to you because I think they're relevant. The court held that all these elements are met and the injunction should be granted. Now, in doing so, they actually worked through the mock analysis quite a bit And I thought the court did a good job at that. One thing they did note that the plaintiffs in the mock case clearly demonstrated a likelihood of success. And this court actually relied a lot on that analysis in the first element, that do these plaintiffs in the Brito case have a chance or substantial likelihood of success? And they said, look, in the mock case they clearly did, and here they would as well. So the court said, in addition to the circuit panel's holding that the rule failed the logical outgrowth test, the braced pistols subject to enforcement of the final rule are in common use today, and possession and use of braced pistols is therefore within the ambit of Second Amendment protection. So again, they're citing back to what happened after the mock case. So that was a Fifth Circuit case, so a court of appeals. So what happened is after the appeals court put that stay on it, it was remanded back down to the district court, and that's what the district court held. There is a substantial likelihood of success based on those two factors. Then the court goes into discussing irreparable harm. The big part of this was that these various Marines obviously would be harmed. They own these guns, so if this is enforced against them, there's an irreparable harm. But in addition to that, there's cost. There's cost to engraving the guns. There's cost in time into registering the guns. I think the ATF or the government hypothesized that it was going to be over 10 years, like $1 billion to enforce the rule, if I remember correctly. But it was a lot of money. So they said there's obviously an irreparable harm here. Regarding the public interest element, element 3 and 4, the court actually, and I want to quote this, they said it fails the logical outgrowth test and violates the APA and therefore must be set aside as unlawful. Well, enforcing an unlawful rule cannot be, for public good, right? It follows then that there is no injury that the government, defendants, or public at large could possibly suffer from if enforcement of the rule were enjoined. And here we go, last page here, I'm reading my notes. It does actually say that the 10-year cost was over $1 billion, so I stand a little bit corrected there. All right, and they also mentioned as far as irreparable harm, some dealers and manufacturers who relied heavily on armed braced weapons actually had to close their doors, so they did cite to that as well. A couple more quotes here that I find relevant to kind of bring you all up to speed. It states that the court is not insensitive to ATF's concerns over gun industry gamesmanship and attempts to circumvent the NFA's restrictions on SBRs. I call that following the law, but what do I know? Continuing. However, the government may not simply posit that the regulation promotes an important interest to justify its regulation, and they're citing the Bruin in that. So I wanted to read that because I thought that was a very insightful quote. So again, at this point in time, as I understand it, there's a nationwide stay on the arm brace rule not being enforced. I wanted to bring you all up to date on that. I appreciate your time. I appreciate everybody tuning in, and we will have more content. I'm really thinking we're doing a better job of getting the content out to you guys. Follow us on the podcast, Munitions Podcast. Stay with us here on YouTube. More information to come. I'm going to continue my restoration series, and we're going to continue to try and hit on the current events of the day in the firearms industry. With that said, make sure you guys have a Merry Christmas, and as always, be safe and carry on. Thank you.